What if refusing an offer cost you your financial future? Not in theory, not in fiction, but in a real courtroom, in a real marriage, where one decision changed everything. This is the story of Mr. James Calderbank and Mrs. Mary Calderbank, once united in life, later divided in one of the most influential financial disputes in legal history. Mary came from inherited wealth. Money passed through generations. She had stability, property, and the stronger financial position. James did not share that advantage, yet he was confident that the courtroom would reward him more than any private proposal she might offer. When their marriage fell apart, emotions rose higher than logic. Mary made a settlement offer, strategic, measured, and more generous than most would expect. She didn't make it casually. She marked it with a powerful legal phrase, without prejudice except as to costs. It meant the offer would stay hidden during the case, but could be revealed after judgment when costs were decided. James refused, not because the offer was unfair, but because he believed he could win more by going to court. The case first went before Justice Halbrun, who made a ruling less favorable than the proposal Mary had put forward. But the story didn't end in that courtroom. When legal costs were disputed, the case rose to the Court of Appeal, where Lord Justice Scarman, Lord Justice Cairns, and Lord Justice Orr presided. Their decision reshaped financial strategy and legal disputes forever. What began as the end of a marriage became the birth of a powerful legal and financial principle. This is Calderbank v. Calderbank, a case where ego met consequence and the cost of saying no became a lesson for generations. Stay with me, because before the story ends, you'll understand how a single decision can define your financial future. The marriage and the money. Before the courtrooms, before the letters and the lawyers, there was a marriage, one that began like many others, with trust, comfort, and the belief that partnership could weather anything. James Calderbank and Mary Calderbank did not enter their life together anticipating courts or consequences. Like countless couples, they built a world around assumptions, emotional, personal, and financial. Mary came into the marriage with inherited security. Her wealth was not the result of sudden success or reckless spending, but family assets, built over time and passed through generations. She understood that money wasn't just paper or numbers. It was protection, leverage, and stability. Though she lived comfortably, she was not extravagant. She carried the mindset of someone who knew what it meant to preserve rather than chase. James stood on a different financial foundation. He did not enter the relationship with comparable assets, but marriage has a way of making financial lines disappear, or at least blur. While he may not have matched her resources, he matched his own expectations to the lifestyle they shared. Over time, comfort can feel like ownership, and stability can begin to look like entitlement. To outsiders, the marriage looks secure, emotionally at times, financially for certain. But behind the calm surface, differences in money thinking were always present. Money means something different to the one who brings it in than to the one who learns to live within its shelter. These unspoken differences don't always surface while things are good, but when relationships begin to fracture, they rise quickly to the surface. As the years went on, what once felt like unity began to feel like separation. Conversations turned to negotiations. Silent tensions became spoken disagreements. Every ending begins quietly, and theirs was no different. Before any legal steps were taken, something more important had already happened. Trust had eroded, and with it, the willingness to compromise. When a marriage unravels, money becomes more than currency. It becomes a battleground. Not because people are greedy by nature, but because they fear loss more than they value peace. For Mary, her assets represented legacy and responsibility. For James, they represented fairness, compensation, and a chance to rebuild beyond separation. And this is where the true divide began. Not in court filings, but in financial perception. Mary viewed resources through preservation. James viewed them through entitlement. Both believed they were justified. Both believed their position made sense. But belief and outcome rarely walked the same road. By the time their relationship fully collapsed, the emotional distance was matched only by the financial one. Conversations about reconciliation had turned into calculations about division. Neither of them could yet see that one choice, one decision about an offer, would soon define the outcome of their story. What they did next would echo far beyond their own lives. A private conflict was on the verge of becoming a public principle, not because of who they were, but because of what they chose to do with the money between them. When marriage ends, people think the fight is about who gets what. But more often, the real battle is about what each person believes they deserve. James believed the court would favor his position. Mary believed in protecting what she brought into the union. Neither could predict that their private dispute would become a global legal reference point. The groundwork was laid, the emotional distance was set, the financial imbalance was clear, but the defining moment of the case hadn't happened yet. It would arrive in the form of a letter, an offer, a chance, and a decision that would cost far more than either of them expected. The separation and the offer. When the Calderbank marriage ended, it didn't collapse overnight. Like many relationships, it eroded slowly through distance, unspoken frustrations, and emotional fatigue. By the time lawyers entered the picture, love was no longer the issue. What remained was far more practical: assets, expectations, and the question of who should walk away with what. Mary Calderbank came into the separation with inherited wealth, property and capital passed down through her family. She wasn't desperate, she wasn't reckless, and she wasn't emotionally driven in the negotiation. She understood something many people overlook. Court battles don't just cost time. They cost money, reputation, and control. James Calderbank, on the other hand, believed the legal system would secure him a better outcome than anything offered privately. In his mind, accepting a proposal meant surrendering. He thought court was a path to more, not a risk of less. He saw the offer as a limitation, not an opportunity. That moment of decision would define everything that followed. Mary, guided by clarity rather than emotion, made a settlement proposal. She offered an asset valued today at roughly $15,000 to $17,000, a figure that would have resolved the dispute before it escalated. It wasn't aggressive, and it wasn't symbolic. It was deliberately structured to avoid a courtroom fight. But the true power of that offer wasn't in the dollar amount. It was in the legal phrase she attached: without prejudice, except as to costs. 6 quiet words that most people would skim over, words that hide in legal letters, rarely explained, often ignored. Yet those words would end up costing James more than he could ever foresee. Here's what they meant. The court wouldn't see the offer during the main trial, but after the ruling, when legal costs were discussed, the offer could be revealed. And if the person who rejected it ended up with less than what was proposed, the court could punish that decision financially. Mary didn't threaten, she didn't argue, she prepared. James read the proposal and dismissed it, not because it was unfair, but because he believed he'd win a better result through litigation. Pride disguised itself as optimism. He didn't see the trapdoor under his feet. When the case went to court, Justice Heilbronn evaluated the evidence and made an official award. The final judgment granted James an amount equal to roughly $12,000 to $14,000 in today's value, less than the offer he had refused. That should have been the end. Judgment made, case concluded. But this was the beginning of the real financial consequence. Those 6 words, without prejudice except as to costs, were waiting in the background, silent but loaded. They allowed Mary to reveal that she had offered him more than the court eventually awarded. And that changed everything. What started as a marital dispute was about to become a financial lesson carved into legal history. The emotional separation had turned into a strategic confrontation. The offer was more than a negotiation. It was a test of judgment, and the cost of saying no was now about to surface. When you hear the next part, you'll see how a single rejected opportunity became a global principle. The courtroom gamble and the costly mistake. When James Calderbank rejected the settlement offer, he didn't believe he was gambling. He believed he was positioning himself for a bigger win. Court, to him, wasn't a risk. It was a chance to be validated, compensated, and perhaps even rewarded for walking away from a marriage where he felt financially disadvantaged. What he didn't see was the silent cost meter running in the background. Legal battles don't just drain wallets. They drain optimism, time, and rational decision-making. Once the court process begins, emotions start disguising themselves as arguments, and pride starts wearing the costume of justice. The case was brought before Justice Heilbronn, a respected judge known for her measured decisions. She listened, she evaluated, and when she reached her ruling, the outcome was clear. James would receive a financial award, but it was less than what Mary had originally offered him privately. At that moment, for most people, the lesson would have landed. But James believed the verdict was at least a partial victory. He thought that winning something in court justified rejecting the earlier settlement. What he didn't grasp was that the courtroom isn't just about what you get. It's about what it costs to get it. And the cost was just about to present itself. When the initial ruling concluded, the focus shifted to something many people underestimate: legal costs. In family disputes, especially at that time, there was a common expectation. If a spouse received any financial award, the other spouse might be expected to cover their legal expenses. James assumed that tradition would protect him, but that assumption collided with strategy. Mary's legal team revealed the existence of her earlier offer, marked with the phrase, "without prejudice, except as to costs." That one line allowed the court to consider the settlement after judgment had already been made. Now the judges at the Court of Appeal, Lord Justice Scarman, Lord Justice Cairns, and Lord Justice Orr, had to decide whether James should be rewarded for pursuing litigation or held accountable for rejecting a better deal. They made their conclusion clear. If you turn down a reasonable offer and go to court expecting more, but end up with less, you should face the financial consequences. They ruled that Mary would only cover James's legal costs up to the date of her offer, not beyond it. From the moment he rejected it, the financial burden shifted. He would be responsible for her costs after that point. The court wasn't punishing emotion. They were rewarding practicality. They were signaling something powerful, Settlements aren't weakness, they're strategy. This was the moment the Calderbank Offer was born, a precedent that still affects legal and financial disputes today. Here's the lesson many people miss. James didn't just lose money, he lost the power to control the cost of his decisions. He assumed winning in court was only about the award, not the aftermath. He assumed rejecting the offer meant keeping his pride, but pride doesn't pay bills, especially legal ones. And Mary, she didn't fight harder. She prepared smarter. She didn't negotiate emotionally, she negotiated defensively. She understood something most people learn too late. The cost of being right can be higher than the price of being reasonable. This wasn't just a courtroom outcome, it was a financial turning point that still teaches individuals, lawyers, negotiators, and business people one truth. The real danger isn't losing in court. The real danger is winning less than what you were offered and paying more than you expected. The gamble wasn't in the law, how the ruling changed financial strategy forever. The outcome of Calderbank wasn't just a legal resolution, it was a shift in financial strategy that would influence negotiations, settlements, and personal decision-making for decades to come. What began as a private dispute became a global lesson in how to protect your money before entering a legal battlefield. Before this case, many people believed going to court was simply about proving a point or securing a judgment. Most didn't think deeply about the financial aftermath, especially when rejecting a settlement offer. Lawyers focused on arguments, not risk exposure. Clients focused on fairness, not financial consequences. But the Court of Appeal changed that thinking. By allowing Mary Calderbank's earlier offer to influence who paid legal costs, the judges made something unmistakably clear. If you ignore a fair offer and fight unnecessarily, you may pay for it, even if you win something, and that changed everything. From that moment on, smart negotiators, both in family disputes and beyond, began using what became known as the Calderbank Offer. It wasn't just a legal tool, it was a financial shield. It allowed someone to say, I'm trying to settle this reasonably. If you refuse and force a fight, and you don't do better than what I have offered, you'll pay the price. This principle reshaped how lawyers advised clients. Instead of pushing every case toward litigation, they began asking a crucial question. Is the risk worth the cost? People stopped assuming that going to trial was a free gamble. Businesses began incorporating similar strategies in commercial disputes. Investors used it in high-stakes negotiations. Even outside the courtroom, the psychology of Calderbank thinking became part of deal-making. Don't reject a good offer out of pride. Don't fight when the numbers don't favor you. Don't confuse emotion with leverage. Don't assume a courtroom guarantees a better outcome. The ruling didn't silence conflict. It disciplined it. It introduced a mindset still relevant today in matters like divorce settlements, corporate disputes, contract negotiations, insurance claims, property divisions, and employment disagreements. The message was universal. The smartest player isn't the loudest, it's the one who calculates risk. Even outside legal systems, the logic became financial wisdom. If someone gives you a deal that's better than the likely outcome, take it. If your ego tells you to fight, but your numbers say walk away, listen to the numbers. If a victory costs more to win than it gives in return, it's not a victory. People began viewing settlements differently, not as surrender, but as strategy. The real winners weren't those who fought the longest, but those who knew when to end the fight before it drained their resources. And here's the deeper financial lesson the world took away. It's not the decision to fight that ruins people. It's the refusal to calculate. James Calderbank didn't lose because he was wrong. He lost because he didn't measure the cost of being right. Mary didn't win because she was wealthier. She won because she used knowledge as leverage. One phrase, no one without prejudice, except as to costs, and became proof that financial power isn't just about money. It's about foresight. This case taught individuals and investors alike that litigation is not a strategy, it's a last resort. A good offer is an asset. Ignoring it can become a liability. Costs don't end when judgment is given. They continue in consequences. And perhaps the biggest shift of all, it made people understand that financial intelligence isn't about winning arguments. It's about mastering outcomes. From boardrooms to mediation tables, from divorces to corporate disputes, the shadow of this case lives on in every negotiation where someone must decide, is this worth fighting for, or is this the moment to walk away smarter? When you're ready, I'll move on to the next 15-minute segment. Lessons for your wallet, how to never overpay for a fight. From legal drama to financial blueprint, how this case shapes real-life decisions. The Calderbank case may have begun as a private dispute, but the ripple effect of its outcome transformed it into a financial rulebook for anyone who negotiates, argues, or risks money in conflict. What happened between James and Mary wasn't just a marital breakdown. It was a demonstration of how refusing a reasonable offer without calculation can cost more than the dispute itself. The legacy of that case now stretches into business, family settlements, contracts, investments, and everyday decision-making. People often assume that delaying or rejecting an offer makes them stronger or more strategic. In reality, waiting too long can turn an advantage into a disadvantage. James believed that by refusing Mary's proposal, he was positioning himself for a bigger win. What he did not recognize was that timing decides value, not defiance. This same mistake plays out daily in business negotiations, family property discussions, partnership disagreements, and legal conflicts. An early offer may carry more value than it appears, but if someone ignores it, because they think holding out is power, the decision becomes a gamble rather than a tactic. Mary's victory didn't come from aggression, it came from preparation. Financial intelligence is not only about earning or winning, but about avoiding unnecessary loss. Many financial disasters don't occur in the courtroom, the boardroom, or the negotiation table. They happen before those moments when someone assumes there is nothing to lose and everything to gain. Knowing when to accept a fair settlement can protect you more than winning a drawn-out fight. The Calderbank ruling taught that the smartest financial move is often the one that prevents escalation rather than proving a point. A powerful lesson from the case is that every rejected offer has a cost attached to it. Many people think that when they turn something down, it disappears. It doesn't. It stays in the background and often reappears with consequences. James rejected an offer that was better than what he eventually received from the court. And because of the legal note attached to it, that decision followed him into the ruling on costs. This happens today in countless disputes. Someone refuses a payout only to spend double in legal fees. A person fights over property and loses more to attorneys than the asset was worth. An individual rejects contract terms and ends up with worse conditions and higher expenses. The danger isn't disagreement, it's ignoring the financial math behind that disagreement. One of the strongest lessons from Mary's approach is the importance of documentation. Her offer wasn't just spoken or implied. It was written, structured, and labeled in a way that gave her protection even if the dispute escalated. That single phrase, without prejudice except as to costs, ensured that the court could revisit her offer after judgment and use it to decide who paid the financial penalties. The same mindset applies beyond law. Anyone dealing with settlements, contracts, family assets, business partnerships, property deals, or employment conflicts needs to understand that if an offer isn't documented, it isn't protected. Preparation on paper is protection in reality. Another financial truth from this case is that the best deal isn't always the one that comes from a judge, a contract, or a negotiation win. Sometimes the best outcome is the offer you turned down because you thought you could do better. People lose money every day, not because they're wrong, but because they reject offers that already meet their goals. They expect the process to deliver more than the proposal in front of them. But, as this case proved, if you end up with less than what you rejected, you may also be held responsible for the cost of rejecting it. This applies in divorce disputes, commercial deals, inheritance arguments, employment settlements, and partnership exits. The smartest move is often recognizing value before the fight strips it away. When you look at the Calderbank case as a whole, a clear blueprint appears. Don't fight a battle whose outcome doesn't justify the cost. Don't let pride speak louder than your bank account. Don't assume refusing an offer is safe. Don't measure winning by emotion or ego. And don't wait for judges or lawyers to fix what preparation could have prevented. James didn't just take a financial hit. He lost control of the outcome because he didn't calculate the risk. Mary didn't overpower him in court. She outprepared him before they ever arrived there. The true legacy of the case is simple. Protect your money before the fight, not after. Every financial dispute, no matter how personal or professional, has a moment where you can choose foresight over friction. Those who see it early keep the resources. Those who ignore it pay the price later, turning conflict into financial advantage. Conflict is often seen as a loss, a disruption, or a setback, but the Calderbank case revealed that conflict can also be turned into financial advantage when handled with foresight instead of emotion. What destroys most people financially isn't disagreement itself, it's the way they respond to it. Those who understand how to navigate tension, protect their position, and use timing to their advantage often walk away not just intact, but ahead. In many disputes, whether personal, business, or legal, people make the mistake of entering a conflict with emotion rather than calculation. They believe that standing their ground automatically means strength. Yet the Calderbank ruling showed the opposite. Strength is not about resistance. It is about positioning. Mary proved that by acting early, putting her offer in writing, and framing it correctly, she took control of the outcome long before the final decision was made. That is what turning conflict into advantage looks like. Preparation that converts risk into leverage. Too many individuals assume that the real power lies in the courtroom, the negotiation table, or the final decision maker. In reality, the power sits with whoever frames the terms before the conflict escalates. Mary didn't wait to see what the court would do. She didn't hope fairness would sort itself out. She set the ground rules by making a clear, reasonable offer and protecting herself with language that preserved its value. When James rejected that offer, he didn't just refuse a proposal, he walked into a trap of his own making, and the law allowed the court to penalize him for it. That is the difference between reacting to conflict and using conflict to your advantage. Financial advantage during conflict also comes from understanding that silence is not weakness, it is strategy. Mary did not argue, justify, or plead. She simply prepared. James, on the other hand, spoke louder through action, not reason. He assumed that litigation would grant him more than negotiation. He believed that court was an opportunity rather than a cost. His refusal to analyze the consequence of rejection is what turned his decision into a liability. When people ignore the cost of conflict, they unintentionally hand over financial control to circumstances instead of maintaining it through design. In every kind of dispute, there is a moment where numbers must speak louder than pride. That is where advantage is either seized or surrendered. The Calderbank case became a symbol of this reality. A fair offer, properly structured, is not just a gesture of settlement, it is a financial safeguard. And if the other party walks away from it, the law may protect the person who made it, rather than the one who rejected it. The principle can be used in divorce cases, business breakdowns, property disagreements, inheritance splits, and commercial negotiations. Conflict is not a loss when the groundwork is designed to turn resistance into accountability. Another way conflict becomes advantage is through controlled documentation. A verbal negotiation leaves nothing to protect you. A phone call disappears. But a written offer, backed by legal phrasing, can transform future costs. Mary did not rely on interpretation or memory. She relied on structure. That is why her offer resurfaced after judgment and reshaped who paid the financial price. Most people enter conflict with words. The ones who benefit from it enter with proof. There is also a mental shift involved in turning conflict into advantage. People often believe that winning means forcing the other side to lose. But the true financial victory lies in ensuring that even if the dispute continues, your position remains insulated. Mary didn't win because James lost. She won because she refused to lose when he chose to fight. That is not aggression. It is preparation meeting opportunity. The Calderbank principle showed that the best way to profit from conflict is not by escalating it, but by designing the outcome before escalation begins. When conflict hits, most individuals react emotionally, speak impulsively, or wait for someone else to decide their fate. Those who gain from conflict do the opposite. They create terms that reward acceptance and penalize rejection. That is the difference between confrontation as risk and confrontation as leverage. In modern life, that approach still applies. People who structure settlements properly avoid years of legal bills. Business owners who document negotiations prevent costly disputes. Partners who make reasonable offers before escalation often end up protected even if the fight continues. Conflict doesn't ruin those who prepare. It ruins those who assume preparation isn't necessary. Turning conflict into financial advantage is not about aggression, manipulation, or dominance. It's about clarity, timing, proof, and restraint. The Calderbank ruling wasn't just a legal moment. It was a masterclass in how to win before the battle begins. Conflict will always exist. The question is whether you enter it armed with ego or equipped with strategy. Those who choose strategy don't just survive the dispute, they benefit from it.